Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I'm coming to you with a video talking about a recent trial in New York and the verdict, and getting in depth, getting into the nitty-gritty about this case, what happened, what were the injuries, what was the liability, and also then there was an appeal. So we'll talk a little bit about the appeal. But actually, to be honest, I haven't research this case. This was an email that I received just this morning. So it's almost like a live, because I'm going to be discovering this information along with you. We could discover it together. So it's a little bit exciting. I love these cases. I love learning more about it and learning how the courts think, both the trial court as well as the appellate court, and also learning how the lawyers craft and structure their cases and build the strongest possible case to get the maximum possible result. How do these lawyers for the plaintiff do it? And these were very good lawyers for the plaintiff. And then how do the lawyers for the defendant defend and lower the amount, and what are their tactics? And they're very good lawyers for the defendant too, because this was actually a construction accident case. So construction accident cases fall under the labor law. And under the labor law, a worker is protected if they fall from a height. So if the worker is working and they're on a scaffold or on a ladder, and the employer, let's say, not really the employer, but the owner of the job site or the general contractor on the job site, if they fail to provide what's known as proper protections, right? If they fail to do that and the worker falls, then it's automatic liability, meaning there's no issue as to fault because they should have provided proper protections, because everyone knows working in construction is inherently dangerous. So if you didn't provide proper protections, then the only issue is damages. And the damages are very high because you have lost wages, you have future medical costs, you have pain and suffering, loss of enjoyment of life. So the damages in these cases often runs into the millions. So this was a case that happened in March of 2010. This is an old case, but the appeal just came down recently. So it's interesting, let's see how long these cases take. So March of 2010, this particular individual, his name was Mr. Marquez, and he sustained injuries to his knees and back. He fell from an A-frame ladder in a construction site, and he was painting crown moldings in a common hallway. So he was in a hallway of a cooperative building. It was on West 79th Street in Manhattan, and there was some construction, and part of it was, it's important to note that it was a common hallway, right? Because that's now you're implicating the whole building. Because if it was just somebody's apartment, well then, there's no construction, there's no general contractor, and the owner of the entire building may not be liable. And then that may not be a case, right? So it's important. So he was in a common hallway and he was painting a crown molding, and he fell from an A-frame ladder. And so he was only 33 years old when it happened. He was working as a commercial painter for this restoration company. And so he sued the building owner, which was known as a tenants corp. But the building owner is just the landlord, but the landlord under the labor law, under section 240, is responsible, right? They're one of the parties that is automatically responsible, the owner as well as the general contractor. So he sued the owner under the labor law, claiming that the owner was liable for his injuries because the ladder was unsecured and defective. Now, it doesn't say exactly how the ladder was defective, but I've done a lot of these cases. It could be that the ladder was not secured. They could say the ladder should have been more secured. It could have been tied or somehow secured to the structure, to the wall, or the floor could have been made safer. Sometimes construction debris could be on the floor, and one of the legs of the ladder is standing on, like, say, a pebble. Now it's shaking, so you could fall off and get hurt. So so basically there was a trial, and after the trial, the verdict was for the plaintiff, and the verdict was actually a really, really substantial verdict. The verdict was pain and suffering was $2,049,900. That included $683,300 for past pain and suffering, and $1,366,600 for the future. And the future was for 20 years. So that was the pain and suffering, award, and that was from the jury after a trial. Now, the injury details were that in his right knee, he had a torn meniscus requiring 2 arthroscopic surgeries. In the left knee, he had a torn meniscus requiring 2 arthroscopic surgeries. So now it's a total of 4 surgeries. But those are relatively, I don't want to say minor, but they're not as significant as, say, a fusion or like a total knee replacement. That would be much, much more significant. But still, he had those surgeries. In his back, he had a herniated disc at L4, L5, and L5S1, and those are 2 levels in the lower back. The L5S1 is the final level. It's the lumbar fifth and the sacral, the first sacral. And those herniations required a fastectomy and a laminotomy. So he had a back surgery for the lower back as well. And plaintiff's treating surgeons testified that he'll need a bilateral total knee replacement in the future, as well as a lumbar fusion. So he didn't have these yet, but the surgeon said, look, with a reasonable degree of medical certainty, this particular patient is going to need a future lumbar fusion. He is going to need a future total knee replacement. So that's why I think the future number was higher. The past number was 680,000, and the future number was 1.3 million for the pain and suffering. Now, for the medical expenses, the past award was 357,266, and the future amount for 33 years of medical expenses was $3,490,299. So the total medical expenses, this is the jury verdict, was $3.8 million, $3,847,565. And then the lost earnings were also allowed in the amount of $149,277 for the past and $100,469 for the future, and they gave him a future of 6 years of lost wages. So the lost earnings total was $249,746. So that's that's almost $250,000, $250,000 for lost wages. Medical costs were $3.8 million, and pain and suffering was $2,050,000. So the total verdict was $6,147,211. So it was a pretty good, pretty nice verdict for what it is. And that's what, that's what I've been talking about in some of my prior videos, that these cases where you have labor law violations, construction accidents, they tend to be higher. Because if this was like, let's say, a car crash and you had like 2 torn meniscuses, even if you had 4 surgeries for them, and even if you had a back surgery like a percutaneous discectomy, or even if somebody needed a full-blown laminotomy like he had, a more invasive surgery, but it's not going to go for 6 million. First of all, you need the insurance, right? The insurance might be 100,000, and then you're stuck with that. But even if, let's say, you got hit by a truck and you had more insurance, I think a case like that maybe would settle for, it could be into the millions, sure, but would it be 6 million? Probably not. It'd probably be like 1.5, 2 million, 3 million, but 6 is a pretty good number. So that goes to show that labor law construction cases tend to be worth more than other cases. So what else? What else is interesting about this case? So the defendant appealed. They didn't like this verdict, they appealed, and they claimed that various rulings by the trial judge were unfair. And they also said that the pain and suffering amount included a large part damages for injuries not connected to the accident. So they were arguing causation. They were saying that all these injuries are not related to this fall. And also they said that the future medical expenses amount was not based upon legally sufficient evidence or proven with reasonable certainty. So they're saying like future medical expenses, 4 million just for future medical expenses, but you have to prove that with reasonable certainty. So that was basically the case. This is the write-up. This is actually, I'm getting this information from something known as the New York Cases blog, the New York Injury Cases blog. It's another lawyer, and he writes a blog, and what he does is he does a lot of research into all these, cases. And as the decisions come down, sometimes when the decisions have to do with whether or not a verdict should be sustained on appeal, he'll write about it in his blog. So I thank him for that. It's a lawyer named Mr. Hochfelder. He's pretty good, pretty good lawyer, very good researcher. And it's very interesting because this gives us the information, the information to then discuss it and do a deeper dive. And sometimes I read the actual trial transcripts. You can go on NYSIF and read the trial transcripts, and you could read the appeals, and you could get a little bit deeper. But like I said, this one, I haven't done that. I just got this email this morning, and I just thought I would do it because it sounded very interesting, because I'm actually working on a few construction cases right now, like labor law cases. So I thought this is right up my alley, and it's helpful for me to learn for myself, for my own practice, but also I thought I would share it with my audience. So some inside information. He offers some inside information. He says the plaintiff's future medical expense amount that the jury awarded in the jury verdict, that $4 million, $3.8 million, it was based upon the expert's life care plan and testimony, which included $1.2 million for home health aid costs, $376,000 for physical therapy, $970,000 for knee surgeries, and $2,236,000 for back surgeries. So that's how the future medical amount, breaks down, because you can't just say, hey, give me $4 million, right? You have to justify it. So he had a life care plan expert, and the testimony was that it was $1.2 million for home health aid. So that's pretty significant. $376,000 for physical therapy, $970,000, almost $1 million for the knee surgeries. I guess he needed multiple knee surgeries, probably the total knee replacement, and $2.2 million for back surgeries. So the defendants did not present their own life care plan at all. They just cross-examined the plaintiff's life care planner. And then the other inside information is the attorneys. He had two attorneys. They're both very good attorneys. I've heard of them. I don't know them personally, but they're very good attorneys. And so they said that they would settle the case for $5 million before the trial even started. But the offer from the defendants before the trial was only $375,000. So you see, that goes again, like if you have a good attorney who's willing to go to trial and willing to take a verdict and knows what they're doing, you're better off taking a verdict, because the best that these attorneys, even though they're very preeminent, famous attorneys with a history of verdicts, in fact, one of them, I believe, is always recognized as a super lawyer and always recognized as one of the attorneys who gets the highest verdicts in New York year after year after year. So even despite all that, right? Despite all that, the insurance company's offering them $375,000 total for everything, for pain and suffering, for loss of enjoyment of life, for the human damages, for all the medical expenses is included in that, right? All the lost wages is included in that. But they destroyed that offer. I mean, they got $6 million. So what is that, like 20 times, right? 20 times the offer. So let's take a look at the appeal. So the defendants appealed, and the appellate division, this was the first department, the appellate division. This was, by the way, a judgment from New York County. And the judgment was entered in October of 2022, so about a year ago, and it took about a year for the appeal to be decided. So this was New York County, which is Manhattan. Basically they said that the appeal was just unanimously affirmed without costs. And they said that the personal injury action is that he fell and sustained injuries when the ladder on which he was standing while painting a foyer outside an apartment twisted and slipped out from underneath him. Okay, so the ladder twisted. So probably it wasn't placed securely. Something was wrong with the floor. I mean, it could be also something was wrong with the rung or with the leg of the ladder. That could be a possibility. Defendant's counsel wanted to get testimony of a non-party who had been working with the plaintiff at the time of the accident, but the witness was not cooperative and refused to appear voluntarily. The defense counsel wanted to subpoena the witness and asked the court to issue a warrant for his arrest, which the court did, but as a result, the witness was restrained in handcuffs as he testified during defendant's case in chief. And the defendant did not preserve his argument that the trial court erred in failing to order the witness's handcuffs removed or give the jury instructions regarding the issue, as the defendant did not ask for that relief during trial. Oh, I see. So they didn't like the verdict, right? That was $6 million. So now they're saying that the judge did something wrong because there was this witness, I guess another construction worker, and he just didn't want to come to court. So they issued a warrant for contempt of court because there was a valid subpoena. And so the marshal or the police went to this guy's house, arrested the poor guy, put him in handcuffs and brought him to court and made him testify on the witness stand in handcuffs. Like, I don't know why they would do that. So I guess maybe, you know, and because that was a witness technically for the defendant, I don't know what the guy said. Probably he would say something like the plaintiff wasn't paying attention, or, you know, somehow blaming the plaintiff since it was a defense, you know, witness. But anyway, but the point is that this witness didn't end up helping, you know, and now the court said, look, if you didn't like that he was in handcuffs, you should have objected then during the trial. You can't bring it up now that you don't like the verdict. So anyway, so then they said there was no error and it did not take away from the defendant substantial justice or affect the verdict such that we would remove the jury's discretion, right? Because remember, the jury are 6 people with 2 alternates. So you have 8 people sitting there listening to this trial. That's probably going on for at least a week, maybe 2-3 weeks, right? And there's jury selection, which takes a few days. There's opening statements. There's all these witnesses. So what the appellate division is saying, we're not going to say that whatever the jury did is just, you know, so crazy that we're just going to like forget about that because they actually watched this trial, right? It's their discretion. Whatever decision they made is their discretion, right? It's their right to make this decision and whatever inferences they made based on the evidence. So we're not going to take away the jury's power and then substitute our own discretion, which, you know, of course, we're a group of judges and we're very experienced, but why should we take away the jury's discretion and substitute our own? Nothing was so egregious and you didn't even object to it. So just whatever the jury decided is the jurors are the judges of the facts, right? These are factual issues. So they said, let it stand. And so, yeah, so basically that's the issue. So they don't really, and they mentioned that the judge didn't provide any basis for keeping the witness handcuffed while testifying. Yeah, why would you keep the guy handcuffed while testifying? He's testifying. You have court officers with guns. What is he gonna like run away? What is he? I don't really get it. But whatever. That wasn't. I don't think that was a central issue in the case. Next, the court said that they properly redacted a notation in plaintiff's medical records or hospital records concerning the manner in which the plaintiff's accident occurred, because they said this notation was not germane to the diagnosis and treatment of plaintiff's injuries, nor directly attributable to plaintiff. So there was something in these medical records that probably also hurt the plaintiff, but it was not, you know, it was not admitted into evidence. And the reason is because it was not for diagnosis and treatment. You can only admit things that are for diagnosis and treatment. If you have something else in there, it's hearsay, right? And it stays out. So that's the common thing, and they noted that. Now, the next thing they said was that the trial court also providently exercised its discretion in denying defendant's application for a 1-week adjournment when his attorney fell ill partway through the trial. The jury had already been impaneled. The trial had already begun. This was before Thanksgiving. Both parties had spent significant resources trying the case, and had a mistrial resulted from the adjournment, the case would not have been able to be retried by a jury until the following June, right? So I guess the defense lawyer got sick, and they said under the circumstances, there was a 2-day adjournment, so the defendant could retain substitute trial counsel and allow counsel adequate time to prepare. That fell well within the trial court's broad discretion to control its own calendar. So that's another issue, that the defendant got sick, but they said all of these issues are not reasons to disturb the verdict. Now, the final thing, or hopefully this is my final thing, we reject defendant's argument that plaintiff failed to establish a causal relationship between his injuries and the accident. So the defendants were saying, like we mentioned before, right, causation, that this wasn't caused by, and he said, look, the jury considered that the nature and extent of the injuries. They listened to the experts. The experts causally related the injuries to the accident, and they declined to credit the testimony of the defendant's expert that the injuries were either non-existent or, if they were existent, that they weren't caused by this accident. So that was all there, right? They could have listened to the defendant's expert, but they chose not to. And the jury declined to credit defendant's arguments that the accident did not occur in the manner that the plaintiff alleged. Such credibility determinations are properly made by a jury, and defendant has not offered or has offered no basis for disturbing these determinations. Right, so like we said before, that's just the jury's providence, right? That's their role, and there's no reason to disturb it. So they said, given the nature and extent of the injuries, we also reject defendant's assertion that the jury's award for pain and suffering were excessive. So they said the injuries were serious. You know, this guy needed these surgeries. There's no basis to say it's excessive. So they left it. And then finally, they said plaintiff's evidence was sufficient to prove his future medical expenses with the requisite degree of reasonable certainty. And they cite to some case law on this. And they say, furthermore, defendant waived his argument that the jury's award of future medical expenses over 33 years is inconsistent with its award for future pain and suffering over 20 years because it failed to raise the issue before the jury was discharged. Oh, okay, so that's an important thing, right? So that is inconsistent, right? So they're saying pain and suffering, we're going to give you money and it's for 20 years. But future medical expenses, we're going to give you for 33 years. So that's a difference of 13 years. So wait a minute, if you're only going to have pain for 20 years, why are you going to need to go to the doctor for 13 more years, right? It doesn't make sense. But they said you have to make that argument. The defense lawyer should have made that argument when he heard the verdict while the jury was in the box, before the jury was sent home. Otherwise, he didn't preserve it, right? You can't make it now on these appeals because we don't know what the reasoning was. So they just denied that. And they said the future medical expenses did have enough requisite. That means just like the requisite, the required degree of reasonable certainty. And that's what we talked about, like how they broke it down into things like the cost of the back surgeries, the cost of the future home health aides, the physical therapy. We broke that down earlier in the video. So tell me what you think. I mean, I think this is good. This is a good verdict, and it's a good result on appeal. $6,147,211. I think he had good counsel. It did take a crazy long time from 2010. 2010 accident, and it's only getting resolved today. Not today, but like fairly recently. The appellate division decision was October 24th, 2023. So, about a month ago. So he probably hasn't even seen the money because the appellate division decision just came down. So now that it's been affirmed, now they're going to have to send the money. But, plus interest. So that's good. But yeah, tell me what you think. It's an interesting case. Okay, please like and subscribe to our channel. Feel free to comment. If you need to text me for a consult, 347-566-9595. That's about it. Have a great day, everyone. I think this is an interesting case, and it's a win for the good guys. It's a win for the plaintiff because even though it took so long, he got $6 million, and it's all sustained, right? It wasn't reduced in any way. Okay, have a great day, everyone. Bye-bye.